Attorney, Mr. DeCastro, do you wish to make any response to what Ms. Peter just testified to?
Sure. Listen, it's true that I don't like police. That's 100% factual. However, I'm not anti-government. I'm pro-government. I'm pro having a Bill of Rights and a constitutional standard. So that is true, but saying I'm anti-government is completely false. I'm for petitioning, assembling, and legislation. And then furthermore, I've never said I'm going to her house on a live stream. I would now redirect to the district attorney for perjury. She perjured herself several times just now. My home address is on her Discord account. My home address is on her Discord account in California. My cell phone number is on her Discord account, which she should have removed. It's doxing me. And then a credible threat of violence. I've never threatened. I didn't ask her to follow me around. This idea that she has a First Amendment right to audit me, I am not a public figure. And it's clearly defined what a public figure is, and that's not me just because I have a YouTube channel. I've announced that one day I'm going to run for governor, but that doesn't make me a public figure because I've never raised campaign funds and I've never started a campaign.
Welcome to one of the most bizarre courtroom showdowns you'll ever see, where YouTube drama meets real-life legal proceedings. Meet Chille DeCastro, a self-proclaimed constitutional warrior and anti-police activist who's convinced the system is rigged against him. Across the aisle, Kate Peter, an outspoken critic accused of doxing and harassment. But here's the twist. Chille claims he's not a public figure, despite building an online empire around his own controversies. This isn't just a hearing. It's ego versus evidence, live stream fame versus courtroom fact. And by the end, Chille's tangled logic will start to unravel before everyone's eyes.
The idea that she's tracking my movements, they posted where I'm at in Ohio, then she says we're tracking him. It's not funny. I'm tracking Zachary Hillman, like an endangered great white. We know his every move. That's not funny. That causes intentional infliction of emotional distress. If you're tracking me and you're posting where my whereabouts are, this isn't something they're just doing through my live stream. As I proved a moment ago, he just crossed over the Maryland border. I wasn't. That's incredible. That's incredible. Endear herself to the court and try to say that rude to a cop at the court. I'm rude to a cop. Like cops. That's my right. Now I can't move into violence or project violence. And then she said that I wish the cop would get shot. That's not true. That's absolutely incredible. That's incredible. And then she says, it's that the only thing I've ever said, whether it have been harsh or not, and used Cohen versus California from 1971, which gives me the right to free speech, I didn't threaten her in any way, shape, or form. It clearly shows the veracity of my emotional state when I'm saying, leave me the fuck alone. Stay away from me. She makes videos about me every single day.
Here's where things start to spin. Chille swears he's not a public figure, even though he runs a public YouTube channel, campaigns for office, and thrives on attention. It's a mental gymnastics routine. He wants the spotlight without the scrutiny. That logic may fly in comment sections, but not in court. When you broadcast yourself to the world daily, you don't get to suddenly play private citizen. The judge's quiet restraint here is telling. She doesn't even need to interrupt. Reality is doing that job just fine.
You're not allowed to harass and stalk someone. And whether she endears herself to the court or not, case precedent is clearly established. 3 or more times she's mentioned my location. She's posted account, my location, my address, my phone number. That's going to go right. That's going to go directly to Commonwealth versus Walters. She doesn't have to scare me physically or threaten me with physical damage, according to Agus versus Howard Johnson, 1976. The tracking of me in Commonwealth versus Brennan clearly states that when she lists where I'm at more than 2 times, that is stalking. That is criminal. And in the 1971 case of George versus Jordan Marsh, extreme conduct. Remember, court, I don't know this person. I've never been friends with her. We've never worked together. She admits to calling one person, but it's incredible. She's called Seth. Then on her, called my mother a fat fucking bitch. I don't understand that. I don't know who her mom is. I wouldn't call her mom that. I don't understand it. And then all of the defaming comments she's made about me. If she had endeared herself to another person on YouTube who's going to try to disparage me, it just goes to show there's no limits, no boundaries to what this woman will do to harass. It's incredible. I've laid out clearly the case law. I've laid it out clearly. I've listened to hundreds and hundreds of district cases and Supreme Court cases. I have proven my case beyond a reasonable doubt. This person and I should have no more contact. She should not make videos about me. I should not make a video about her. We should part amicably.
Now it gets surreal. Chille compares himself to a great white shark being tracked. Really, it's a metaphor that says more than he intends, portraying himself as both predator and prey. But the irony is, he's the one chasing confrontation online. The court doesn't see a hunted victim. It sees someone addicted to attention. Every attack he cites is simply online accountability following him back. The courtroom atmosphere turns heavy with cringe. His ocean-sized paranoia is starting to show cracks in the armor.
My friends and me, and you guys just saw on my live stream, Kate always wins over and over and over. The mass calling of my phone when I'm on live stream. That proves in Commonwealth versus Wotan that she is actually harassing me. More than 3 calls is harassing. More than 3. Now, if she's using Google numbers or alternate numbers, who else is calling my phone hundreds of times during my live stream? Who else is doing that? It's her. She's the one harassing me. It's her. I didn't ask for any contact with her, and I never have. But this, and then I think the district attorney should be made aware of the perjury she just committed. It's trying to paint me in a light as though I'm some danger, and I don't have anything like that in my record. Matter of fact, the only conviction that was listed in my record was disorderly conduct from when I was 19 years old. That was almost 30 years ago. I mean, so I am a man of law and order. I believe in rule of law. I believe that America has lost its way and we're not living by a constitutional Bill of Rights standard. And that's all I'm trying to do. I do not wish harm on police. I don't like them, but that's my right not to like them. Our prison system's out of control. So, I am not a public figure. New York Times versus Sullivan. I'm not a public figure. No matter how this person tries to interpret, she's incorrect in her data. It's not true. I'm not a public.
This is where Chille takes a swing at constitutional gymnastics. He wields Cohen versus California to defend his rants, insisting he's just exercising free speech, yet denies that right to others. It's a stunning display of selective liberty. The very amendment that shields him also protects Kate's criticism. Chille's logic? Freedom of speech for me, silence for thee. The hypocrisy lands like a thud. In court, emotional outrage doesn't equal legal precedent, and the judge knows it. Chille's legal self-defense is eating itself alive.
And I love to troll Chille, and those are the names of their accounts. There's dozens of accounts on her Discord and dozens of accounts on her YouTube that use my name in them. It's not a stretch to know that when I go live, she's posting or someone's posting in their Discord account, and then they're harassing me, which is a violation of Commonwealth versus Wooten from 2015 versus Walters. I apologize. I only had a day to really prep the cases, so sorry if I'm not a little slow.
Madam Clerk, have we received those documents?
I have not.
Did you send those documents?
I can't get to it. If you just tell me the email address, I'll talk.
All right, so this is what we're going to do then. This is what we're going to do. I am not going to make a determination until I see those documents.
What's your email? Send them now. I don't want to make.
We're going to take a recess so that you can send those documents to the court. And I'm going to recall this matter. How voluminous are the documents, Mr. DeCastro?
I can get them over to you as soon as I have the email address, but I can't see it on here. I don't know.
No, I understand that. I'm asking how many pages are we talking?
Are we talking the PDFs or the videos? I can send you video links where she openly says she's tracking me, and then
the PDF. We won't be able to see the videos. We won't be able to see the videos.
My last point is on June 1st, 2022, she announces to her subscribers as she's streaming live, she announces that I'm driving down there, I'm checking in with the Discord. Is he still there? That's not a joke. Then I'm 5 minutes out. He's not getting away. They're telling me he's still there. That's not parody. That's not funny. Mr. Hillman, if I did that to you or Miss Hinkle, the previous judge, could you even imagine how it would go for me? Could you even fathom?
Mr. DeCastro, Mr. DeCastro, how many pages is the PDF document that you're going to send over?
47.
I'm just 47. All right. So then what we're going to do is I'm going to take a recess so I can review the documents that you're going to send over so that I can review the cases that you've cited. And we're going to recall this matter at 2 p.m.
Excuse me, Honor, just to kind of make it easier on you when you're going through this voluminous document, I'd like to give you my Discord username so that you can see what I've posted, because it sounds like Mr. DeCastro is vacillating between admitting that these are other people and then trying to attribute it directly to me. So I can give you my my Discord username here.
We're also going to provide you, Ms. Peter, with copies of what is coming into the court, since you have a right to see those as well. So we will recall this matter at 2 p.m.
That's going to be, that'll be
2 p.m. Eastern Standard Time.
Your Honor, in the meanwhile, Mr. Hillman, in the meanwhile, can you make it so that she can no longer harass me using these harassment proceedings? Because what she'll do is she'll go out right now.
No, I'm not going to do that. I'm not going to issue any order until I see the evidence that you're going to present, and I've had an opportunity to review that. Go ahead, sir.
I just didn't get a chance to bring in the witness who I have on hold, and I don't know this man. I only know him from online. He said himself he was the target of Kate before, where he received hundreds of phone calls, thousands from her followers, disrupted me during work, lured me to a bar where I was then threatened in a parking lot by her thugs. She posted my personal information, including my number, online. That's a policy and practice, sir. And I actually have him on the line right now to tell you his story himself. And this is the fourth person who I've tracked down that she's done this to. One of them, I believe, is in court there, so he will no longer be the focus of her.
At this stage, Chille's drowning in case citations like a student who discovered Google Scholar yesterday. Walters, Johnson, Brennan. He fires off names as if quantity equals quality. But law isn't about memorizing case titles. It's about context. And that's where he collapses. Even worse, he claims Kate mentioning his city is stalking, while he publicly live streams his location himself. The room fills with second-hand embarrassment as everyone realizes this isn't a legal strategy. It's a YouTube comment thread disguised as a closing argument. 222222222222222.
What did you understand that to be in regards to? Were you physically coming from Ohio into Massachusetts?
I was actually leaving the Northeast when I was going through Maryland just night before last, and that's on the Discord, which you have in that email, where they say he's crossing over the Maryland border, heading south. So they're tracking me all the time, 24 hours, no matter where I go or what I do. If I do turn on my camera and I show any part of the location I'm in, they'll tag it and put me on their Discord account so I can be tracked. And she said, what, there's 1,600 people in there? That would put a reasonable person.
Is whether a harassment prevention order pursuant to Chapter 258E should issue. The question before the court today is whether, and the only basis on which 258E could issue based on the evidence that I've heard today, would be whether there's been a showing of criminal harassment pursuant to Chapter 265, Section 43A. Much of what has been reported to the court today involves speech and conduct that could be considered to be protected under the First Amendment, and so the court is mindful that any speech that would be considered as a basis for criminal harassment would have to constitute a true threat or fighting words. I cite ASR versus AKA 92 Mass App Court 270. So with that background, my findings are as follows. Mr. DeCastro and Ms. Peter do not know one another personally. Approximately 30 days ago, Ms. Peter began to post videos on YouTube regarding Mr. DeCastro. She linked to these videos via her Discord account. She also posts messages to her approximately 1,600 followers on that same Discord account. The name on the Discord account and the YouTube posts that she reports under are mass hole reports. The purposes of, Mr. DeCastro, I'm just going to ask you to let me make my findings on the record. The purpose of Ms. Peters' posts regarding Mr. DeCastro